This has happened in some other cases against Diddy too, where the lawyers just aren't, or the judges just aren't buying the idea that these cases need to proceed under the John Doe or Jane Doe name. That some different judges have done different analysis and said that they can remain anonymous, but we've seen several orders already saying that the filings can't be under John Doe. And that means that after these orders are issued, the lawyers go and file an amended complaint that instead of John Doe or Jane Doe actually names the people in the case. So that's what's going to happen in 3 cases now under these judges' orders. But this is the one order that was just recently issued. Of course, all of this is coming as Diddy has his trial coming up in May, and it still looks like that's actually going to happen in May. I think there was a lot of talk early on that it would get delayed because I think a lot of people were expecting him to get co-defendants and superseding indictments, but that hasn't happened. There's been superseding indictments, but that have added a couple more victims, but we have not seen any co-defendants or additional charges. So right now, Diddy's trial is set to begin with jury selection. I think they were going to bring in the jurors a little bit early to fill out questionnaires, but they're hoping to get opening statements going by like May 12th or something. So once his criminal trial is complete, that's when we're really going to see, we could see some resolution of the lawsuits. I'm not really sure. A lot kind of hinges on what happens with the criminal case, obviously, but none of these have gotten to the discovery phase as they're as we're talking about this. But this is the order yesterday that a judge who has 2 cases against Diddy issued. It's an identical order, and she's rejecting the request to proceed anonymously. It's a 12-page order that she issued. Got it on the screen here. Need to zoom in for you guys. Thanks for tuning in, everybody. And this was issued in both cases. She rejected anonymity in both cases. So that means, I think it's by April 10th, then 2 weeks, they've got to file the amended complaint that actually names them. And I think in the previous cases we've seen this order issued, nobody has dropped their case. I think everybody has identified themselves, but perhaps we could see that going forward. Maybe somebody will just want to drop their case instead of identifying themselves. But so far, we've seen everybody identify themselves and not just drop the case moving forward. But the judge goes over some of the case law here. And a lot of the times, it's pretty standard that the judges all have law clerks who work for them, usually pretty recent law grads. And it's usually pretty standard that the law students or the law grads are the ones who actually wrote the order. And that could be here. But sometimes, especially in a high-profile case, you'll see a lot of input from the judge, or maybe they'll write some of it themselves. But it's pretty standard that you have law clerks that do a lot of this research and write it. But it says the court finds that the sealed plaintiff factors, she's citing a case here, weigh against allowing plaintiff to proceed anonymously. And she's going to address the factors in detail here. And the first factor is this litigation involves matters of a highly sensitive and personal nature, factor 1, and plaintiff has thus far kept her identity confidential, factor 7. And it says the first and 7th sealed plaintiff factors weigh in plaintiff's favor. So she's saying this weighs in favor of anonymity, starting with the first factor, because neither party disputes that this litigation involves highly sensitive matters of a personal nature. So the first factor, does it involve highly personal matters of a sensitive nature? And the 7th factor is whether her identity has been kept confidential. It says is no indication based on the current record that plaintiff has spoken publicly about her allegation. And this is, to be clear, this is a woman who accuses Diddy of attacking her in, I think it was 1991. So these cases really run the year span. It's one of the cases was 1991, one of them's 1998, and then the one that was just issued by another judge today is in a case in 2022, or an allegation from 2022. The case was filed this year, late last year. Judge says defendants further contend that plaintiff may have spoken privately to others about her allegations without receiving assurances of confidentiality. But this is pure speculation and would not necessarily tip the scales in defendant's favor, even if it were true. And I thought this was interesting. It says, the Buzbee declaration supporting defendant's motion states that plaintiff has not spoken publicly about the incidents that underlie the causes of action in her complaint. But as defendants acknowledged, the declaration is neither sworn nor made under the penalty of perjury. And I think that goes to the fact that Buzbee does not have standing. He's not admitted to the Southern District of New York, so he was probably worried about filing stuff like that. I'm not totally sure. There's so many questions about this. Procedurally what he's doing in this case. But it says that the court also notes that the declaration is substantively identical to declarations filed on the same day in other Doe versus Combs cases in the district involving different plaintiffs and facts, which raises serious questions about the declaration's reliability. Yeah, that's why this kind of like warehouse assembly line litigation that they're doing, filing so many cases, when you would read the complaints and a lot of their filings, it's pretty minimum what's actually different in the filings. It's just the bare bones facts of the case. But when they're filing declarations that are the same in each case, like the judge says, it raises questions about the credibility. But she did say in any case that the seventh factor still weighs in plaintiff's favor, absent any evidence that plaintiff's identity has not been kept confidential, because the seventh factor is apparently just strictly has her identity been kept confidential, and the answer to that is yes. But like I said, the judge ultimately ends up ordering her to identify herself, so she gets into some of the factors about why that is. So it says plaintiff's allegations regarding the risk of harm are speculative and insufficiently particularized, and that's factors 2, 3, and 4. It says the second, third, and fourth sealed plaintiff factors task the court with assessing the potential risks associated with identifying the anonymous party, including the potential for retaliatory physical or mental harm and the severity of such harms. On balance, these factors weigh against allowing plaintiff to proceed anonymously. She says, with regard to the second and third factors, which evaluate the risks that identification would present and the likelihood of those physical and mental harms, plaintiff asserts that Combs made, quote, threats of violence after the alleged assault. Combs told plaintiff that people can come up missing when she told him she wanted to report the assault. However, plaintiff provides no support for these allegations beyond this vague and unsworn Buzbee declaration, and she has not identified any present threat of physical harm. Generally, to justify the exceptional relief of proceeding anonymously, plaintiff must establish with sufficient specificity the incremental injury that would result from the disclosure of her identity. But plaintiff has not done so here. Likewise, with regard to the risk of mental harm, plaintiff contends that the playing out her traumatic experiences in a public forum could spark more trauma. But she provides no medical documentation or other evidence of the severity or likelihood of mental harm that would result from the disclosure of her identity. I think a lot of people would think it just seems obvious, but when you're dealing with a court and a judge, you can see why maybe she would want that. Plaintiff relies heavily on Combs's pending criminal charges to establish that Combs and the people within his organizations are dangerous. But plaintiff does not allege that she was the target of any of the conduct in the indictment, and there is no evidence that Combs has been in contact with plaintiff or made any threats in the last 3 decades. This is the woman who says she was attacked in 1991. And so the fourth factor here is whether the plaintiff is particularly vulnerable to the possible harms of disclosure, and the key being particularly vulnerable here. And it says plaintiff is currently an adult, was not a minor at the time of the alleged incident, and has not identified any reason for the court to treat her as more vulnerable from the great run of adult plaintiffs who bring allegations of sexual assault in their own names. Yeah, and that's the thing. They're just looking for you can't just be like everybody else. They're looking for what's particularly vulnerable about you. I mean, I think everybody could argue they're vulnerable, but I think the key there is particularly vulnerable. So again, this is the ruling saying that the woman suing Diddy has to identify herself. And this judge issued the same ruling in 2 cases yesterday. And then another judge in another case issued a similar ruling saying that a man suing Diddy for allegedly assaulting him in 2022 has to identify himself. So, and you can find the links to these on my X page. I've got that link down there. If you guys don't follow me on there, you should. But give me a subscribe, give me a like. Let me know how everything's going. But it says plaintiff relies heavily on it says plaintiff relies heavily on Combs's pending criminal charges to establish that he and the people within his group are dangerous. But again, it says that she doesn't say that she's been the target of any of that. And so then they get into the 5th, 8th, and 9th factors. It says the public interest factors cut both ways. It says turning first to the 5th factor, which looks into whether the suit challenges the actions of the government or that of private parties. Here, plaintiffs challenge the actions of private parties. Thus, there is a significant interest in open judicial proceedings weighing against the use of pseudonym. Next, the 8th factor weighs whether the public's interest in the litigation is furthered by revelation of the plaintiff's identity. And it says this factor weighs in both directions. As courts have routinely observed, lawsuits are public events, and the public has a legitimate interest in knowing the facts involved in them. And she's citing a previous order where they rejected anonymity in the Combs case, and the order apparently cites a lawsuit against Tupac Shakur from 1996, or Doe versus Shakur. Make sure that's actually Tupac. There is also a public interest in the accused being able to publicly confront an accuser, a right that would be undermined by plaintiff's anonymity. The public interest in knowing the identity of the parties is magnified where a plaintiff has made the allegations against a public figure. But courts have also noted that the public generally has a strong interest in protecting the identities of sexual assault victims so that other victims will not be deterred from reporting such crimes. Lastly, the 9th factor suggests that I'll turn the page for you guys here. So yeah, I think this is the one that gives them until April 10th to file an amended complaint identifying them. Says, as defendants correctly observed, there are other mechanisms to protect any confidential information that may be disclosed during discovery or as part of the case. It says blanket anonymity would significantly prejudice defendants, and that's factor 6. In such a situation, when one party is anonymous while others are not, there is an asymmetry in fact gathering. This asymmetry is more profound in cases involving substantial publicity because information about only one side may come to light as a result. And that's been the argument we've seen in the other cases, is that they want the public should know who it is because they might have information about what happened. And of course, we're seeing that happen with Diddy with all the lawsuits coming against him. But I think the defense attorneys for him are saying that perhaps people in the public would know something about the accusers' credibility, but they're not coming forward because they have no idea who the accusers are. So this is the judge weighing that right here. She quotes case law, confidentially disclosing the plaintiff's name to the defendant's counsel, as plaintiff's counsel suggests, would not eliminate the potential prejudice. The potential prejudice to defendants is particularly stark here because plaintiff is bringing a lawsuit about an incident that allegedly occurred approximately 20 years ago, which may be difficult to defend even with information about plaintiff's identity. They're citing another case here. In this case, they were saying it's like 30 years ago, 1991. So it says, accordingly, the court finds that the 6th factor weighs strongly in favor of disclosure. And then this is coming to the conclusion here, the balance of factors weighs in favor of disclosure. On one hand, the case involves highly sensitive personal allegations. Plaintiff has thus far kept her identity confidential, and the public has a particularized interest in encouraging the victims of sexual assault to confront their accusers, who are often powerful figures. On the other hand, plaintiff brings factually grounded claims on a topic of significant public interest against a well-known figure, and the public also has a strong interest in maintaining the customary and constitutionally embedded presumption of openness in judicial proceedings. And significantly, plaintiff has not provided any particularized evidence or even non-speculative allegations to establish that the disclosure of her identity would result in concrete physical or mental harm to herself or third parties. Such evidence plays a vital role in the balancing of competing interests in these cases, and its absence is particularly salient here given the risk of severe prejudice to defendants from continued anonymity, hampering their ability to confront their accuser, guard against reputational harm, and defend an action based on events from more than 3 decades ago. Yeah, there's 30 years. In sum, plaintiff has not provided the court with enough information to tip the scales in her favor. Conclusion. For the foregoing reasons, the court denies plaintiff's motion to proceed anonymously. Plaintiff shall file a complaint in her own name no later than April 10th, 2025. The clerk of court is respectfully directed to terminate the motion at docket 15. That's the motion that she just decided, the motion about whether the motion requesting to proceed anonymously. It has been rejected and the motion is terminated because it is resolved. And that was yesterday's order. And she issued a similar order, except addressing Jane Doe as John Doe in another case against Diddy that she's also been assigned the judge. And that's a case where a man alleges he was attacked by him in 1998. And then today we had the other case filed. So, yes, Queen, I did cover the Judge Viscal response to Curris for the playback crew. They could find that early in the setting, but yeah, we did go over that. And yeah, she's in trouble. I mean, I think Buzbee's kind of plan to kind of set her up to take the fall for him is kind of working. Like, she's not really in trouble. He's not in trouble in that particular situation, but he could be in trouble overall in the New York State Bar, and just all his lawsuits are getting screwed up in the Southern District of New York because he's withdrawing from all these cases, and it's unclear whether she's going to be capable of like going to court and litigating all those on her own. But she's ordered to be in court on April 14th, and she has to, it's an order to show cause. She has to show the judge, like, basically why she shouldn't be sanctioned for saying something that isn't true in a sworn filing. And it's, what's notable is that the judge gave her kind of an easy out on this excuse me, gave her an easy out on this back in the order, and just said that, you know, don't do this again, or said that she would take this seriously if it happened again, that kind of thing. And she ended up filing a really kind of snotty response to it, like basically telling the judge that she was wrong. And so this is the judge's order day. I've got this on Twitter if you guys can see it.